Welcome and thank you for standing by. At this time, all participants are in a listen-only mode. During the question-and-answer session, please press star one on your touch-tone phone if you'd like to ask a question. Today's conference is being recorded. If you have any objections, you may disconnect at this time. I'd like to turn it over to Ms. Melissa Grasso. Ma'am, you may begin.
Great. Thank you so much, and good afternoon, everyone. Thank you for joining us for today's webinar on export controls at trade shows. I'm Melissa Grasso with the U.S. Commercial Service, and we're in our final week of the 17-part webinar series, so thank you guys, those of you who have hung in with us throughout the multi-week, multi-month series, where we hope you got a lot of good information from this series. Our final webinar, as you can see on the screen that's up now, is this Thursday on export controls in the cloud. But again, today's webinar is focusing on export controls at trade shows, and we recognize that trade shows are an important part of many companies' international business development strategies. So on today's webinar, we're really looking forward to addressing when companies are required to obtain authorizations for information shared at trade shows, as well as other relevant considerations when attending trade shows. And our speaker on today's webinar, you heard from her at the very beginning of the webinar series, Tahlia Townsend, who's a partner at the law firm of Wiggin and Dana. Tahlia has a plethora of experience in the international trade controls realm and actually co-chairs the international trade compliance practice for her law firms. So Tahlia, thank you so much for joining us. Give me 1 minute and you should have control of the slides. Thank you, Tahlia, for joining us.
Thanks very much, Melissa, and thanks to everyone for attending, and congratulations on achieving pretty close to the end of the series. I think I heard there's just one more to go. And I think that we will have plenty of time today, so I plan to pause periodically and ask if anybody has any questions rather than waiting till the very end, at which point you might be too exhausted to ask any questions. So I will pause. If we start to run out of time, then I'll accelerate and leave time for questions at the end. But it's my plan to stop at various points and let you know that I've stopped so that you can ask any questions you have about that segment. And with that, let me jump into the agenda here. So we're going to start by just some recap. For some of you, this will be less interesting, some of you who are more familiar with the regs, but I want to make sure always that we have an opportunity to get everybody on the same page for those who are less familiar with the regs. So we'll have a little bit of review on how exports can happen at trade shows, and then on when authorization might be required and what authorizations are commonly used by folks going to trade shows, and denied party screening, which is often on people's minds as a topic of some difficulty for trade shows. And I'm going to talk about a variety of other things that may not be obvious and that not everybody always thinks about, but that can certainly be traps for the unwary. Make sure that you have a full view of all of the things you might trip over when planning for an international trade show. And then again, there'll be time at the end for further questions if anybody has any. And if you want to ask questions that you don't feel comfortable asking during the webinar, feel free to look me up on the web and send me an email. My email address is on the front cover of the presentation, which I believe you will receive as a PDF after today's webinar. All right, so how do exports happen at trade shows? And I'm going to focus primarily on international trade shows as opposed to trade shows here in the U.S., but we will talk briefly about trade shows at home towards the end of the presentation, just to make sure we don't overlook the potential export issues that can arise there. But focusing on international trade shows, let's look at the definition of export, just to remind everybody the various ways in which exports can occur, and then we'll apply that to the trade show context. So one of the facets of an export, one of the ways it's defined, is the obvious one, the actual shipment or transmission of controlled items out of the United States. And those items might be hardware that you're planning on taking with you, either to demonstrate or display at a trade show. They could be the written materials that you're planning to take with you to explain the products at the trade show. Or they could be other types of information that are controlled, because as you will recall, U.S. export regulations apply to hardware, but also to software and to certain types of information. And so, for example, if you're traveling with a laptop and you work for a company that has controlled information, and some of that controlled information is on your laptop, when you take the laptop with you to the trade show so that you can multitask and do some work while you're there, that information is also being exported on your laptop, and you would have to think about that. Furthermore, and similarly, if you're sitting at the trade show and you're logged in by Citrix or VPN trying to multitask and get some work done, that may also constitute an export of the information that you are accessing remotely to the country that you're sitting in at the trade show. So actual shipment or transmission could be the hardware, the obvious stuff that you're taking with you to the trade show, but it could also be a variety of other things, and we'll talk about that in some more detail later. Then the second prong of the definition of export is the release, which could be orally or by visual disclosure, of controlled information or software to a foreign person or to a foreign place. In this case, if you're distributing materials at the trade show, that would be an export of those materials to the countries of the people that you are exporting them to. So in the first segment, we saw that if you take the materials with you, that's an actual transmission out of the country, and that's an export. But in addition, every time you distribute them to somebody at the trade show, that is also an export, and that's an export to the country from which the person comes. So at an international trade show, you might be in France, but you could well have attendees from all over the world. And every time you give them information, you are exporting that information to the countries that they traveled from. If you are doing a demonstration of hardware, then you're not exporting the hardware itself to them, but the demonstration may reveal information about the product and how the product operates and the technical capabilities of the product. And you will have to consider whether that information revealed by the demonstration is itself controlled. Let's imagine that you do a demonstration of an unmanned aerial vehicle. Those are all very sexy products these days. Lots of folks are jumping on that bandwagon. And let's imagine that you're actually showing people how to fly it. That kind of demonstration could easily reveal information about the operation of the UAV, and that information may or may not be controlled and may or may not require some kind of authorization for you to transmit it. So that would be the exhibition or demonstration of hardware. Line item on this slide. And then what about the possibility that attendees might come up to your booth and start asking questions about the products? If you engage in a technical discussion about the product's capabilities, something that goes beyond mere marketing information, then that could constitute an export of controlled information that may or may not require authorization. And we're going to talk about authorization in just a moment. The last two rows on this slide are really ITAR specific. The first two would be true for items that are subject to the EAR and items that are subject to the ITAR, but the last two are ITAR specific. So under the ITAR, that is the International Traffic in Arms Regulations, for those of you who are less familiar, in addition to controlling exports of items out of the country physically and the transmission of controlled information, the ITAR also controls defense services, which are services which convey assistance to foreign persons in the operation or use. Those are the two categories most relevant to trade shows, but also the design, development, production, manufacture, repair, maintenance, et cetera, of defense articles. And just as a quick reminder, a defense article is an item that is described on the United States munitions list. And typically that's going to be an item that was specially designed for a military application. So if you were to, for example, demonstrate ITAR-controlled hardware, that may constitute assistance to the foreign persons watching the demonstration in the operation or use of that defense article, and that would be a defense service, and that may require authorization. Simulator training for an ITAR-controlled aircraft or an ITAR-controlled piece of hardware of some other kind that requires a simulator would likewise be a defense service. And then the final category, and this is a little unlikely to be relevant at most trade shows, but in the event that you are selling something, for example, like an unmanned aerial vehicle or an underwater autonomous vehicle, and in the event that those items are ITAR controlled, and you get really lucky and somebody is really excited and wants to buy one, and you go ahead and make the deal then and there at the trade show, which doesn't happen very often, but certainly could happen, then you would have to consider the possibility that that sale, if the item is ITAR controlled, and if it's an aircraft or a vessel or a satellite, then the transfer of ownership accomplished by that sale would also be an export. So those of you who are in the ITAR business and dealing with aircraft or vessels or satellites also need to have that in mind and put the brakes on before actually accomplishing a sale should such an opportunity come along. All right, so that's some of the ways in which exports can happen at trade shows, actually taking the stuff with you and performing demonstrations and providing materials about the products to the foreign participants at the trade show. So when do you need authorization for those exports? There are a few different buckets of situations in which authorization is required, and we're going to talk about these in some more detail. But at the very high level, there are comprehensive controls, and for those, you always need authorization for any item. It doesn't matter if the item is sensitive, it doesn't matter if the item is subject to the International Traffic in Arms regulations, or if the item is subject to the Export Administration regulations. All items are going to require authorization in the situation that you are participating in a trade show in a country that is subject to a comprehensive embargo. It's unlikely that you would be doing that for other reasons, but just for completeness, we've included it here. Similarly, there are end-user controls, which we'll talk about a little bit later, and end-use controls, and any transaction that that poses an end-user control or an end-use control situation is going to require authorization, just at the very high level. The more common situation that you're going to have to deal with at trade shows would be classification-based controls. These are controls that depend on the type of items that you are displaying at a trade show and how those items are classified. And at the very high level, as a recap for folks, products from the U.S., hardware or software or information, may be subject to the International Traffic in Arms regulations, or they may be subject to the Export Administration regulations. And if they are subject to the International Traffic in Arms regulations, then all exports of those items, taking them physically to the trade show, distributing materials about them, are going to require a license or an exception if the hardware or the information is, in fact, subject to the ITAR. Furthermore, if the items are subject to the ITAR, there are a whole bunch of countries for which authorization is not available. You just can't take ITAR hardware to those countries, and you cannot distribute ITAR-controlled information in those countries. And we'll talk a little bit more about what those countries are and some other restrictions that apply. But those countries are listed in 126.1 of the ITAR. In addition, in the ITAR space, so if you're dealing with ITAR-controlled hardware or information, and you go to a trade show, it may trigger something called brokering controls. These only exist under the ITAR. They don't exist under the EAR, so it's only a problem for those of you who are dealing in ITAR-controlled hardware and technology. And we'll talk again about those controls, those brokering controls, in more detail later. Another unusual or different aspect of the ITAR that is relevant to trade shows is that temporary imports of ITAR-controlled hardware and materials also require authorization. And that's going to be relevant, for example, for U.S.-based trade shows. If you're working with partners overseas and or you're a foreign company seeking to bring ITAR-controlled items into the U.S. On a temporary basis, you may need authorization for that as well. So that's on the ITAR side of the world. On the EAR side of the world, authorization is going to be required depending on the export control classification number of the hardware or software or information that you need to share with the foreign persons of the trade show, and the country of the trade show, and the countries of the participants at the trade show. And we'll talk about that in a little bit more detail as well. So this is just, the next slide is just another way of looking at the information that I just provided you. So as you will remember from the prior slide, it was very important to know whether the items were subject to the ITAR or to the EAR. So that's the first thing that we have to ask. If the hardware or the information that you want to share at the trade show is subject to the ITAR, that is, if it's on the United States munitions list, then as I said, you're always going to need a license or an exemption in order to be able to perform that export. and you won't be able to go to 126.1 countries, and you might have to worry about brokering rules. But if you're outside of the ITAR world, then you ask yourself if it's subject to the EAR, the Export Administration Regulations. And in some cases, you may find that the item is not subject to regulation. And this is going to be true, and the most relevant category of this for trade show applications is that general systems information, very high-level general product descriptions, are not considered to be controlled technology or controlled technical data, and they're not subject to the regulations, and so they can be distributed pretty freely unless certain sanctions controls administered by the Office of Foreign Assets Control apply. We'll talk about those in a little more detail later too. But generally speaking, if something is not subject to the regulations, it can be freely exported except in very narrow circumstances. And so a lot of the marketing materials that you may want to take with you may not be subject to the regulations. You can't just assume that. You have to review them and make a determination about whether they contain any technical information that is subject to control. But as long as they are confined to general systems descriptions, it is quite likely that they will not be subject to the regulations, and you won't need to worry too much about who you distribute them to. If, on the other hand, the item is subject to the EAR, it's not in the NSR bucket, then you have to ask if it's on the Commerce Control List. And if it is not on the Commerce Control List, then it's going to be EAR 99, and it will be freely exportable to the trade show and distributable to the persons at the trade show as no license required. In this case, the authorization for the export is the authority of no license required. And that's going to be true except in narrow circumstances where the end use or the end user are problematic. And we'll talk about the situations in which that might happen later. In most cases, though, probably for a lot of the folks on the phone, some of the hardware that you may want to take may well be on the Commerce Control List. And if it is on the Commerce Control List, that doesn't necessarily mean that you need to get a license from the Department of Commerce before you can take it to the trade show, but it is possible. And so you have to go through the process of figuring out where on the Commerce Control List it is, and then depending where it is, when you find that place on the Commerce Control List, it's going to tell you the reason for control. And the reason for control is going to tell you whether you need a license or a license exception in order to export the hardware to the trade show country and potentially share information about that product with foreign persons at the trade show. So if we'll do a quick reminder of how you do that for items that are on the Commerce Control List, just in case anyone has forgotten or isn't so familiar with this. So you'll remember that you look up the Export Control Classification Number, the ECCN, in the Commerce Control List, and it looks a little bit like those two boxes at the top of the slides here. There's a number, and it gives you a description of the item. And then underneath that, it gives you the license requirements, the reasons for control, which in this case on the slide here in the left-hand box are national security and anti-terrorism, NS and AT. And then you have to look at something else called the Commerce Control Chart, and you look up the reasons for control, and you look up the country, and if there's an X in the box, that means that a license or a license exception is necessary. So in this case, if you were dealing with 2E003 technology and you wanted to go to a trade conference in Spain, you would see national security, NS column 1, you go across to Spain, there's an X in the box. It's going to tell you that in order to take that 2E003 technology with you to Spain and potentially to distribute it to Spanish attendees, you would need a license or a license exception. On the other hand, if the technology that you wanted to take with you was 9E991, technology for the use of equipment controlled by 9A991, which is certain kinds of aircraft, then you would be able to take that to Spain without a license because it's only controlled for AT, and when you look at AT in the Commerce Country Chart and you go across to Spain, there's no X in the box. So you can take that no license required to Spain. Just a quick recap of the type of authorization review you would need to do if your hardware and or the information you want to take with you are subject to the EAR. Now, I mentioned at the beginning that there are certain kinds of situations in which you will almost always require authorization, and that would be country-based prohibitions. So let's think about that in a little more detail. There are some countries that are subject to comprehensive embargoes, and that means that it doesn't matter whether the item is ITAR controlled or EAR controlled, sensitive, not sensitive. The United States is engaged in a program of a comprehensive embargo against the country. Cuba, Iran, Syria, Sudan, and North Korea are those countries. And generally speaking, it would be very difficult to engage in trade shows in those countries. If you are offered the opportunity to participate in a trade show in one of those countries, you would have to consider not only the ITAR or EAR requirements. For ITAR, it would be impossible because those are arms embargoed countries. For the EAR, there might be some more flexibility, but you would have to look at the EAR conditions and also at OFAC requirements. OFAC is Office of Foreign Assets Control. That is part of the Department of Treasury that is responsible for administering U.S. economic sanctions. And so for comprehensive embargoes, you always have to think about really three things. Under all of the sanctions regimes administered by OFAC, it is prohibited to export services to these countries. And when you go to a trade show and you provide information on your products and you provide product demonstrations, those would be services to the people attending the trade show. So that's one issue, the services issue. There is also the issue of exporting the goods to those countries. And as the term comprehensive embargo suggests, most products can't be exported to those countries, although there has been some loosening of the restrictions, particularly with respect to Cuba. And then, so there's the issue of services in the embargoed country. There's the issue of goods to the embargoed country. There is also the question of providing services to people who are associated with those countries, that is, businesses incorporated there, members of the governments of those countries, who might turn up at your trade show in another country, like France or Germany or Mexico. With respect to that, there are actually general licenses in place that would allow you to provide services to people from Cuba who show up at a trade show in France or Germany or Spain or somewhere else. So as long as your trade show is not in one of the embargoed countries, you have less to worry about. But certainly trade shows in the embargoed countries are going to be very, very problematic. Not saying there is no way to do a trade show under any set of circumstances, but it's certainly something you would need to talk to a lawyer about before you engage in, because you're going to have to work through the OFAC requirements and the export requirements, and that may be very complicated. Okay, other country-based prohibitions, so basically other situations in which trade shows are going to be very difficult, would be arms embargoes. So under the ITAR, there are a series of countries enumerated in Section 126.1 of the ITAR that are subject to a policy of denial for ITAR exports. And so at the high level, that means not going to be able to take any defense articles to those countries to demonstrate, and you wouldn't be able to release any ITAR-controlled information to those countries, take it with you in your suitcase to those countries, or to people from those countries elsewhere. But in addition, under ITAR 126.1, in addition to the problem of not being able to export the hardware, you also cannot make any sale, export, transfer, re-export, retransfer, or proposal or presentation to sell. So even marketing to a 126.1 country is problematic. So to the extent that you might be thinking, well, I don't have to take the actual hardware with me to the 126.1 country, I'm just going to go and advertise and we'll take a bunch of models and mock-ups. In addition, there is the problem of not being able to even make a proposal or presentation to sell in those countries. So that's important to have on your radar screen. On the EAR side, there is also the equivalent of an arms embargo, and that is that under EAR 744.21, you have to have a license for exports to military end users in China or to military end users or end uses in Venezuela and Russia. Now, generally speaking, the end use and end user controls are not going to be a big deal for you when you go to a trade show because you're not, in fact, exporting items to them. You're not selling anything to those users at the trade show under normal circumstances. You're just demonstrating and marketing the items. But it is still good to be aware of these restrictions because you don't want to spend a whole bunch of time at the trade show courting military end users or folks who are going to use your products for military end uses, because you won't be able to actually accomplish the sale without complex licensing when you get home. Okay, so country prohibitions, I'm going to skip along a little faster here. This is just for your reference later. There's a list of the countries that are subject to 126.1, so those would be the countries for which ITAR trade shows would not be possible. And it also tells you if there is an equivalent EAR issue for that country, and if there are OFAC, that is Department of Treasury, Office of Foreign Assets Control restrictions associated with that country too. I'm going to pause there and see if anybody has any questions so far.
And as a quick reminder, you can enter questions either by typing them into the queue, which is on the lower right-hand side of your screen, or if you press *1, you can get into the audio queue.
Okay, good. We'll see if anybody has any burning questions when we get through the next section. Okay, so I put in a slide on end-use restrictions and end-user restrictions. I'm not going to go through them in great detail here, except as a very brief reminder that there are situations in which an export may require a license under the EAR, so setting aside the ITAR, focusing on situations in which your products are controlled under the EAR. If you know or have reason to know that the product will be exported to a certain end user or for a certain end use. Those, again, are not really relevant in the trade show context because you're not exporting for an end user or for an end use. The only end use at issue is for you to market and demonstrate the product, and that's not a prohibited end use. But it is something to think about when you are speaking with potential customers at the trade show. Because if you have reason to believe that they would be interested in the product for a prohibited end use, then you are going to have a devil of a time making good on that sale when you get home, and you're really wasting your time at the trade show with that particular set of potential customers. So those are just in here for a little bit of reminder and reference. I'm going to skip over them now. And we're going to talk about how you actually can authorize the goods that you want to take with you to a trade show and any controlled information that you may want to take with you. And we're going to break this down by the two worlds, the International Traffic in Arms Regulations world and the Export Administration Regulations world. And under the ITAR, there are a few different ways that are commonly used to authorize hardware and information for trade shows. There are a couple of different exemptions. And as a reminder, an exemption is a method of authorization under the ITAR that does not require you to apply to the Department of State in advance for written permission. It allows you to perform the transaction on the basis of an exemption written into the regulations. You still need to make some kind of internal record of using that exemption, and you may also need to record the use of the exemption in electronic export information when you actually perform the export of the hardware, but you don't need to apply in advance to use it. There are also temporary export licenses, otherwise known as DSP, Department of State Pro Forma 73s. Those are used for the temporary export of hardware. So if you're taking some ITAR-controlled item to the trade show to demonstrate it, and then you're going to bring it back, DSP 73 would allow you to do that. And then there are also permanent export licenses, and you may be thinking, why would I need one of those? I'm only going to a trade show. I'm not selling anything to anyone. But you would need a DSP 5 for any technical data or defense services that you want to export to the trade show or at the trade show. And that's because technical data and defense services are always permanently exported. You can't temporarily export information. Once you put it out there, it's gone. So that would require a permanent export license. Then on the EAR side, there are really three buckets of authorization as well. There is the large bucket of no license required, which again is a type of authorization. It's a type of authorization you don't have to apply for, and that typically applies to the least sensitive of products, that is the EAR 99 items and certain other items. There is also license exception TMP for temporary exports, and in particular, one subsection. This is a very long, TMP is a very long license exception, and it has many, many different subsections that serve many, many different purposes. It's a bit migraine-inducing to work through the whole thing, but subsection 740.9A5 is the one that really applies to trade shows, and we'll talk about it in some more detail in a moment. And then there is the possibility of applying to the Department of Commerce for an export license. If for some reason you can't satisfy the conditions of TMP, then you can apply for a license from BIS. And they don't distinguish between temporary export licenses and permanent export licenses. It's just one type of license from the Department of Commerce. So let's look at those authorizations in a bit more detail. We made a couple of handy-dandy reference charts. Of course, important disclaimer here, not all of the information necessary to comply with the conditions is in this chart. You can't get it all on one slide if you write all the information down. So please do read the text before you use any of these exemptions and read the license carefully if you apply for one and get one. But hopefully this will be a good memory tool for your reference in future. So there are a couple of different exemptions, as I mentioned, under the ITAR that can be useful for trade shows. And the exemptions mean you don't have to apply, you just have to read the regulations and figure out if you can satisfy the conditions. And the first is in 123.16, subsection B4 of the ITAR. And this is an exemption that allows the export of models and mock-ups of defense articles. So if you have an item that is on the United States munitions list and you want to take a model or mock-up of that item with you to the trade show, for example, very often people take model aircraft and put them on their booths, or you want to take some other kind of model with you, it may be that you could use this exemption to do that. Model and mock-up is not itself defined in the regulations, which is a topic of some frustration for those of us who live with it on a daily basis. But what it does say in the exemption is that the model or mock-up of the defense article must be inoperable, and it must not contain any items, any components that themselves are subject to the international traffic in arms regulations. So it's not enough to just make it inoperable. You can't take a real item and just break it and then use it as a model. It cannot have any ITAR-controlled components in it, otherwise it's not eligible. And it must not reveal any technical data. So, for example, if you were to reproduce the model to scale, and you were to show an important technical feature in the model, for example, certain kinds of dimensions that imbue some kind of performance characteristic, or a particular configuration of engine components or wires or something else that is responsible for the performance of that item, that would reveal controlled information about, that is, information necessary for the design or development or production or use of the item. And that would, again, make it ineligible for the model or mock-up exemption. So they really do mean that it has to be a model. It really cannot be, it cannot convey any information about the real item. And unsurprisingly, since we're talking about the ITAR world, this exemption cannot be used to take a model or mock-up to one of those 126.1 countries, one of those arms embargoed countries. If you do go ahead and use the exemption, and you want to take a model aircraft with you, for example, to decorate the booth at the trade show, and you are able to satisfy the requirements of the exemption, you have to certify to CBP, that is Customs and Border Protection, that you have satisfied the requirements of the exemption. Unless CBP tells you that you can do it some other way, that would mean submitting a certification electronically to CBP. And then you also have to have a commercial invoice for the item, and it has to be marked with the appropriate destination control statement, which is in the regulations. And you also, because it's an ITAR item, will have to file electronic export information for that export of hardware so that the government knows that you have exported it. And you're going to have to cite the exemption in the electronic export information when you do that. And that's always true for ITAR exemptions. So that one is somewhat frequently used, but probably more frequently used in the ITAR world is the second one down. This is ITAR 123.16b5. It's the next one in line after models and mock-ups in the regs. And this is for the temporary export of hardware that has already been licensed for a trade show or an exhibition or an air show. And so as an illustration of how this works, let's say you have some ITAR controls hardware or information that you want to take to a trade show in France. And you previously applied for a license, a temporary export license, to take those items to a trade show, those same items, to a trade show in Germany. And the Department of State granted you a temporary export license for export of those items to Germany. And that temporary export license is still valid. They come with a 4-year period, so it's still within the 4 years. Then you would be able to use the exemption to take the same items that are covered by that prior license to a different country, for example, France or the UK, instead of having to go back and get another DSP 73. So you're using the exemption, you're not using the original DSP 73, but the original DSP 73 still has to be in effect. It still has to be valid, and it has to cover the same, it has to include the items that you want to use the exemption for. Now, this can't be used for 126.1 countries. That's not a surprise. But it's also important to remember, and this part is sort of buried in the preamble to the exemptions at the top of the exemption section, so sometimes folks miss it, but it can't be used for items that are on the Missile Technology Control Regime, the MTCR. And those are identified in the USML with a parenthetical that says MT after it. So you can't use it for any Missile Technology Control Regime items, and you also can't use it for any items that are significant military equipment. And that is indicated by an asterisk in the USML entry. So it's a little bit narrow, but it is pretty broadly used. And again, as we were saying before, for an exemption, you are going to have to file electronic export information. You're going to have a commercial invoice that displays the correct destination control statement, and you'll have to provide a certification to CBP that you have met the requirements of the exemption. So using an exemption requires some work. Not as much work as a license application, but it's not something that you can just do instantaneously. It does require working through some conditions and filling out some certifications and keeping proper records. Now, let's imagine that you can't use 123.16, either B4 or B5. Then what are your other options? Well, if you're going to Canada, if the trade show is in Canada, then you might be able to use the Canadian exemption. That's 126.5. There is a trick to using 126.5. It's not as easy as a lot of people think because of something called Supplement Number 1 to Part 126, which is a great big ugly matrix of all of the USML categories, and it tells you which items are excluded from the exemption. So there is a whole bunch of hardware and technical data and defense services that you cannot use the Canadian exemption for. And you have to do the painstaking work of going through the table in Supplement Number 1 to figure out if your items are eligible for the Canadian exemption or not. Not everything is eligible for export to Canada, even though Canada is such a close neighbor of ours. So it does require some painstaking work to figure out if items are eligible for 126.5. And in the case that of a trade show, the items are for return to the U.S., and that is the part of 126.5 that you would be relying on. If the items are SME, then you also have to get a non-transfer and use assurance from the folks on the other end, unless that's you, yourself, of course. But if you were involving a partner entity in Canada and you were exporting the items to them ahead of time, you would need a non-transfer and use assurance from them. Okay, so if you can't use any of the exemptions, that leaves you with the two options, a temporary export license or a permanent export license. Temporary exports, only for hardware, I'll mention again, can't use it for tech data or defense services. So if you are going to take any materials with you that contain technical data, or if you're going to be providing demonstrations that might qualify as assistance to foreign persons in the use of the defense articles that you're taking with you, then you're going to need a permanent export license. But if you're only going to be taking hardware and you're not going to be doing any such demonstrations like that, then a DSP-73 may work for you. Licenses have to be applied for in advance. They may take some time to prepare. Your compliance officer is not going to be able to do that overnight, so you're going to have to plan ahead. And they require quite a lot of detail about what you're planning to take, how exactly it's classified, what its performance characteristics are, exactly why you're taking it, which countries are involved. And when you get it back, it's only valid for those destinations, those parties, those items, and the quantities and values indicated on the license. And this is true for all ITAR licenses. It requires quite a lot of management. Every time you use it, you have to make sure that you present it, or your freight forwarder presents it to Customs and Border Protection, so that they can take off the items that are going out, and then when they come back in, they can add that value back to the license. So there is a process of presenting it to CBP so that they can endorse it and decrement the value accordingly. And then when the items come back in, they can make similar adjustments in the opposite direction. And freight forwarders do from time to time forget to do that. So there is some management headaches associated with DSP-73s. It's just important to be on the ball and keep an eye on the use of those. DSP-73s are valid for 4 years, so you do, if you're planning to go to a whole series of trade shows and kind of go from one country to another, then you're going to have to make sure you get the products back within 4 years. And you have to keep track of the quantity and the value and so on and so forth. And there may also be some provisos on the license. You don't always get exactly what you asked for from the Department of State. Sometimes they send it back saying, well, mostly you can take most of that stuff, but you can't do this and you can't do that, and you mustn't share this kind of information and you mustn't share that kind of information. And so it's important to review those conditions very carefully. And then permanent exports. Similarly, you can apply for license from the Department of State it could be for hardware, it could be for the technical data or the defense services. And again, there are going to potentially be conditions on the license. It's going to take some time to apply for it and then wait for the Department of State to respond. And once you have it, you're going to have to keep track, very careful track of how you've used it and how long it's valid for. Let's see if anybody has any questions about any of that.
Operator, have we had any questions come in over the queue?
Participants on the phone, if you'd like to ask a question, please press *1 and record your name. Make sure your line is unmuted and record your first and last name with the prompt. One moment for incoming questions. And again, participants, if you'd like to ask a question at this time, please press *1 and record your name.
Actually, Tahlia, I have a quick question for you. Under the ITAR 123.16, subparagraph B5, you mentioned the certification to CBP. Does that need to be in a particular format, or is that just something on a company's letterhead that certifies that they meet the conditions of the exemption?
Yes, the latter.
Okay.
So you're going to make sure you have a clear record that you meet the conditions. And CBP may provide guidance on what exactly they want in a particular situation. It's always a good idea to check with them, and they can waive the requirement or instruct you to do it differently. But generally speaking, something on your letterhead that it clearly explains how you satisfy the requirements will do the trick.
Great, thanks. And operator, have we had any questions come in?
There are no questions in queue.
Great. Okay. Well, I'll keep going. And of course, if questions come up as you go through, don't hesitate to put them up, and we'll deal with them as they come in or at a suitable resting spot. All right. So that's really your options in the ITAR world. Just the options on the page here. And as I said, they're not all cost-free. They does require some advanced planning so that you can make sure to cross your T's and dot your I's and create the appropriate records. Okay, what if you're not in ITAR world? You're in the world of items that are subject to the EAR. And I just want to pause here to stress for anyone who's less familiar with these regs on the phone, everything that is located in the United States is subject to the EAR unless it falls in a very narrow category of items that are not subject to the regulations, and that is almost all information, specific categories of information that are not subject to the regulations, published patents, fundamental research, general educational information that is basic, systems descriptions, information that you would find in educational textbooks about mathematical principles. So narrow categories of information that are considered protected by the First Amendment and are not subject to the regulations. But otherwise, everything, no matter how sensitive, is subject to the EAR by virtue of being in the United States. And so you need some kind of authorization to take any of that stuff out of the country to a trade show. The question is, what kind of authorization? And in the many items that are less sensitive in nature are going to be able to be exported under no license required. The nature of the authorization is no license required. This is going to be dependent on the ECCN of your item. So you have to look again at the Commerce Control List and see what the ECCN is. Some ECCNs to some countries are no license required. If you look back at the earlier slide, you'll see that 9E991 data and 9A991 items, for that matter, would be no license required to Spain, but they would not be no license required to certain other countries. EAR 99, which is a big bucket of items which are not on the Commerce Control List and generally correspond to the least sensitive types of hardware and technologies that we have, usually are no license required, but they are not going to be no license required to trade shows in embargoed countries like Cuba, and they wouldn't be no license required if you were actually accomplishing sales to denied parties or for prohibited end uses. Again, those two are not so relevant in the trade show context, though the embargoed country issue can come up in the trade show context. Periodically, people are interested in going to trade shows in, for example, Cuba, and it's very important to work very carefully through that, because even if something is EAR 99, it may not be possible to take it to a trade show in Cuba. Okay, and if you use no license required in order to export hardware or information to a trade show, if the value of different items in buckets of harmonized tariff code, so if each harmonized tariff code item is not worth more than $2,500, you don't have to worry about electronic export information. But if the items are worth more than $2,500, even though you're using an NLR as the authorization, you will need to file electronic export information. And this is something that your freight forwarder may do for you. Most large reputable freight forwarders will offer you the option to have them do it as long as you have a power of attorney with them. But if you do exercise that option, it is important to periodically get those records from the freight forwarder so that you can make sure they did it right, and also so that if they go out of business, you yourself have the records, because you are obliged to keep records of your export activity for 5 years under the ITAR and the EAR. And if your freight forwarder goes out of business and takes all the records with them, then you're in violation of those record-keeping obligations. So if you're lucky, NLR, but that doesn't mean there's no work to be done, it just means there's less work to be done. What if you can't use NLR? So what if your item is on the Commerce Control List, and when you go to the country chart reflecting the country that you're going to do the trade show in, you see an X in the box and you have a license requirement. If there is a license requirement, you can satisfy it in one of two ways. You can satisfy it by identifying an applicable license exception, which is a section of the regulation that lays out certain conditions that if you can satisfy those conditions, you can go ahead and use the license exception without applying to the Department of Commerce. Or you can apply for an actual license. In the case of trade shows, the most commonly used license exception, the most obviously applicable license exception, is license exception TMP. That is located at 15 CFR 740.9, and in particular, in the giant, many subcategories of TMP, you want subsection A5. And this applies to temporary exports of commodities and software, and it calls for items to be returned within 1 year. I'm just going to emphasize that 1-year requirement because a lot of folks who grew up in ITAR world think of temporary exports as a 4-year business, but under the EAR, when you're using license exception TMP, you only have 1 year for your temporary exports. In addition, if you are using TMP for a trade show, you can only exhibit or demonstrate the item exported under TMP at one location for 120 days. So you don't get the full year for a single trade show at a single site. You only have 120 days. So you have 2 clocks that you have to keep an eye on when you're using TMP. There is a carve-out for installation and debugging, so you don't have to count the time that you spend installing it against the 120 days, but you do have to count 120 days after that. Furthermore, you can't demonstrate those items. So anything, you can't do a demonstration that involves showing more than the minimum necessary for effective demonstration. So you really can't be converting your demonstration into detailed training, which is something that sometimes people ask for at trade shows. And ask you to set up a side meeting to do some training for them or something like that, or an existing customer wants a bit more information. If you're doing it under TMP, you really can't cross the boundary between minimum effective demonstration and something more substantive than that. License exception TMP is, some parts of it are valid for some embargoed countries, but this piece of it for trade shows is not available for countries that are in Country Group E. Country Group E, for those of you who don't know, there is a section of the EAR that lists various country groups, and Country Group E includes the countries that are subject to comprehensive embargoes: Cuba, Iran, North Korea, Sudan, and Syria. And TMP is not always available for certain ECCNs and destination combinations. So, for example, if your item is an item that was previously subject to the International Traffic in Arms regulations, it transitioned during export control reform to the 600 series on the Commerce Control List, then it is not possible to use TMP for D5 countries. That's a pretty long list of countries, the D5 countries, but it includes some surprising countries. And to see that, you would go to 740.2. What else do you need to know if you're going to use license exception TMP? Well, you have to maintain ownership and control, effective control of the items while they are abroad. So, for example, you would need to use a designated agent to receive the items in the country when you send them. If your team isn't on the ground yet, then it's going to have to be an entity with which you have an agency relationship, because then you are in effective control via them. But you wouldn't be able to just send it to a friend of yours with whom you don't have that kind of relationship, or a customer, for example. That would not satisfy that requirement. And while you're at the trade show, you also have to maintain effective control. And because you have to maintain ownership, you couldn't just decide to go ahead and sell those items and transfer title. You would then have to get different export authorization in order to accomplish the transfer. When you send them, and folks make this mistake all the time, so I'm going to harp on it for 30 seconds here. When you send items under TMP, subsection A5, you need to list the exporter, that is your own company, as the ultimate consignee, that is the entity that will be receiving the items in the foreign country. And so if you have an agent or you're sending it to some other party with whom you have an agency relationship, you still need to list your own company as the ultimate consignee, care of that receiving agent in the foreign country. Otherwise, you haven't satisfied the requirements of TMP, and the Department of Commerce, through Customs and Border Protection, may be suspicious that you're not really using TMP in good faith. So it's important to get the paperwork right. And again, you're going to need a destination control statement on your commercial invoice for the hardware being exported, and you will need to file electronic export information and make it clear in the electronic export information that you are accomplishing the export under TMP. If you can't use TMP because you can't satisfy all of those requirements, or you have an ECCN that is not eligible for TMP with the country that you are going to, then your option is to apply for a BIS export license. That could include technology. It will likely be approved for 4 years. And like ITAR licenses, these export licenses are only going to be valid for the items, the quantities, and values that are listed on the license. And you will need to keep track of how often you've used it, make sure it's the right country, make sure it's still valid, make sure you still have enough value and enough quantity left on the license. And there may be additional conditions imposed on the license that you will have to keep track of. All right, so those are the common authorizations. If anybody has any questions, they can go ahead and enter them in, and when I see a couple pop up, then I will stop and answer them. Now, I mentioned before that end-user and end-use controls generally are not going to be very important at trade shows because you're not actually exporting items for a particular end-user, and the only end-use is that you're marketing them. But it is the case that under OFAC regulations and under the EAR, there are denied parties. I'm sure you know about the entity list. But under the EAR, the restriction is only on exports to those denied parties. And so as long as you're not actually making a sale or demonstrating to a particular individual, you're not doing an export under the EAR. But under OFAC regulations, that is the sanctions regulations administered by the Office of Foreign Assets Control, you're actually prohibited from providing services to parties on lists of denied entities. In particular, under OFAC, it's the specially designated nationals and blocked parties list. And you're not supposed to provide them with services. Well, when you're at a trade show and you're providing a demonstration or you're having a conversation about your products, OFAC can construe that as a service. And so in theory, you would need to screen every party at the trade show. That's obviously impossible. And so we often get the question, well, what do other companies do? As a pragmatic matter, it's not feasible to screen everybody you interact with at a trade show to make sure that they're not a denied party. But OFAC will expect you to screen in advance parties who you know you are going to have an interaction with. So, for example, the trade show host, any service providers you will be using at the trade show. Those need to be screened before you leave to make sure that you're not going to be engaging in a transaction with a prohibited party. That you're not going to be receiving services from them or providing services to them. And then when you're actually at the show and there are dozens of people coming to your booth, you don't know who's coming and you don't really have an opportunity to screen them. As a practical matter, most companies don't try to screen everybody at the trade show. But if you are going to go beyond the casual interaction of somebody coming up and asking a couple of questions and taking a flyer and going away, if you're going to go beyond that to set up side meetings with parties who seem to be real good live prospects for further business, then that would be a situation in which you would want to hit the pause button and perform screening before you go on to have a more detailed interaction with them. And in terms of embargoed countries, I mentioned before that participants at a trade show who are from an embargoed country, so for example Cuba, there are actually general licenses in the OFAC regulations that allow you to interact with participants from those countries at the trade show. You may not be able to sell anything to them afterwards, and you may not be able to transfer technical information to them, but you can at least interact with them, so you don't have to panic if somebody's badge says Cuba on it. You should nonetheless be alert for red flags because you don't want to invest a whole bunch of time speaking to a person from Cuba who you're not going to be able to make a sale for. In addition, as a best practice, you want to keep your materials out of the realm of export-controlled information because you don't know who you're going to be sharing the information with at the trade show. So your marketing materials should be reviewed before you go to make sure they don't contain export-controlled information. Because if they did, then you would need to know the country of every participant so that you could figure out if the information required a license for that country, which obviously isn't possible. And you would also need to screen every party. So to avoid that, it's a best practice to make sure that the information you plan to share at the trade show is not export controlled. And then when you get home and you have a long list of folks to follow up with, it makes sense to make sure that somebody performs screening on those parties before you engage in detailed follow-up to make sure that you are not engaging in providing services to a sanctioned party. So we've talked about the sort of obvious aspects of trade shows and exports, but I wanted to make sure we covered some less obvious things that we've seen trip people up. I mentioned this at the very top of the webinar, that travel to overseas trade shows can result in exports of items you didn't really intend to export or weren't thinking about exporting, so not just the stuff that you wanted to display at the trade show. For example, your laptops and your telephones, your mobile phones may contain export-controlled information. You need to make sure that you have authorization to take that information on the laptop or in your email on your phone to the countries that you're going to the trade shows in. If you're going to be accessing your email and IT systems containing export-controlled information, you're going to have export authorization for that. If you're going to want to do work on other things while you're at the trade show and that work involves export-controlled information, there needs to be authorization for that. Most companies will have an international travel policy to try to avoid unintentional violations through travel with electronic devices containing technical information. And usually you may be able to use license exception TMP for the EAR controlled information or the ITAR exemption 125.4B9. Broadly speaking, both of those exemptions and exception allow U.S. persons and in some limited circumstances foreign employees of U.S. companies to take export-controlled information with them on travel for personal use or business use that only they are going to use it. It's not going to be shared with anybody else, any other foreign persons, as long as you keep custody and control of it. But there are lots of conditions for using those two exception exemptions, and you need to make sure that you comply with those for any electronic devices you're taking with you. Another potential trap for the unwary in the trade show context for those folks who are involved with ITAR world, that is, if your items are subject to the USML, are on the USML, is brokering. That's because the ITAR doesn't only control exports, but it also controls brokering activities, which are activities on behalf of another, not activities on behalf of your employer, not activities on behalf of other affiliates of your company, but activities on behalf of another to facilitate manufacture, export, sale, transfer of defense articles. And the way that this can come up, for example, is at a trade show. Perhaps you have a friend who works for another company, a foreign company, and they have, recommended that you meet with some people. They've sent some folks your way to see your products, and you would like to return that favor. But if they are also a defense manufacturer and you engage in actions on behalf of them, an unaffiliated company, in order to promote their products, that could well be brokering, and you might need ITAR authorization for that. So before doing favors for other companies promoting their products, or, for example, promoting products that are used by your product, for example, night vision cameras that might be installed on your UAV system, when you promote your system, if you also promote another company's night vision camera, that could be brokering, and you may need authorization for that. You may need to be registered as a broker before you can even get authorization. So definitely worth thinking about on the trade show front if you are dealing with ITAR-controlled goods. I'm going to pause there to see if anybody has any questions.
Again, participants, if you'd like to ask a question, please press *1 and record your name. One moment to see if we have any questions. I'm showing no questions in queue.
Great. Okay. So what else might you need to think about when you are considering a trade show, an overseas trade show? Well, we've talked a lot about U.S. law today, and I'm certainly not an expert on all foreign laws, but I can tell you that there are foreign import rules and also foreign export rules that you need to consider. So if you are taking hardware into a foreign country, first you have to get it out of the U.S., which means you have to think about U.S. export laws. You're going to have to get it back into the U.S., which means you have to think about U.S. import laws. But you also have to get it into and out of the foreign country, which means considering foreign import and then foreign export laws. Some countries don't enforce those laws very much. Other countries are much more enthusiastic and increasingly enthusiastic about enforcing their laws. Those laws could break down into a couple of pieces. So, for example, there may be import duty issues. You don't want to be having to pay import duty on everything you take to the trade show and everything that you bring to the trade show with you. There is a possibility of using something called an international carnet, which is like a merchandise passport, and which allows you to bring your products into the foreign country without having to pay duty on them. It does not substitute for U.S. export authorization, and it does not substitute for import authorization if needed by the foreign country. It just affects the duty issue. And we'll talk in a little more detail about that in a moment. Just for a couple of examples of foreign import laws that you may need to think about, Singapore and the United Arab Emirates both require permits for the import of certain items on their controlled goods list. This is not unusual. A lot of countries have controlled goods lists, and you may need a permit to take items that are on those lists into those countries. Saudi Arabia similarly prohibits, not even requires a permit for, but actually prohibits imports of many goods, some of which might be obvious, like weapons of all kinds. Probably not surprising that those might be prohibited, but others might be more surprising to you. Certain kinds of night vision cameras, certain kinds of antique guns, alcohol, pork, all kinds of other things. So just as a general illustration, when you're getting ready for a trade show, you also need to think about whether there are any foreign import issues to be considered. I mentioned that there are carnets and that those are international customs documents for reducing duty payments, but that they don't substitute for export or import authorization. You can apply for them online. They are accepted by 87 countries if you use the ATA carnet. They're valid usually for a year, but in many cases for trade shows they're only valid for 6 months, which means you would need to be in and out in the 6-month period. The items have to be back in the U.S. Within the 6-month period in order for you to not have to pay duty going into the foreign country. We could do a whole webinar on carnets. They have their own terms and conditions, so you would have to look those up. And there is a fee. The fee basically varies with the value of the goods that are being exported. There is a fee schedule. You can find it online. If you just Google ATA carnet, you will find yourself in the right spot, and there's a lot of information on the website. Another potential trap for the unwary is the anti-boycott laws under the Export Administration Regulations. It's really going to only be an issue for trade shows in broadly speaking, in the Middle East and in some other countries, Singapore, Pakistan, sometimes can be an issue, Bangladesh, Malaysia too. What's going on here essentially is that the U.S. Doesn't allow U.S. companies or foreign companies that are under the effective control of a U.S. company to support boycotts that other countries engage in that the U.S. doesn't approve of. And one of the biggest of those boycotts, or the most common one, is the Arab League boycott of Israel. Those countries engage in an economic boycott of Israel. The U.S. government doesn't approve of that boycott, and as a result, U.S. persons and U.S. companies are not allowed to participate in activities that would further that boycott. And the way that this commonly comes up for trade shows is that you may be asked to complete certain kinds of certifications for customs if you're going to one of the boycotting countries. For example, you might be asked to validate that none of the products you are taking into the country are of Israeli origin. You would not be allowed to do that. You cannot positively certify that they are not of Israeli origin. That would violate the anti-boycott regulations. There are usually some, in those kinds of circumstances, there may be off-ramps. So, for example, you cannot certify that the items are not of Israeli origin, but you can certify that they are of U.S. origin. And in many cases, that will satisfy the customs authority without violating the anti-boycott regulations. Again, we could do an entire webinar on anti-boycott regulations. They're a little complex, but we're not going to do that now because it's really only valid in this, relevant in this narrow situation. Of course, they have broader application, but for trade show purposes, you more often than not are not going to need to worry about it unless you're doing a trade show or contemplating a trade show in one of the countries that participates in the Arab League boycott of Israel. But worth having on your checklist in the event that you do a trade show in that country. Finally, I wanted to have a few words about U.S. trade shows to make sure that we remember that in the case that you are a foreign company or one of your foreign affiliates or foreign subsidiaries is engaging in a trade show here in the United States, there can also be export control issues there. Those can come up in a couple of different ways. For U.S. companies participating in U.S. trade shows, there is, of course, the possibility of performing something called a deemed export. That's where you share export-controlled information with a foreign person in the United States. Even though you're not transmitting it outside of the United States, it's still an export to the country from which that foreign person comes. And so when you are engaging in trade shows within the U.S., it's important to make sure that the information that you distribute or the information that you share by demonstrating your product is not export-controlled information, because you do not know all of the countries from which the participants are coming, and so you can't know whether you need authorization to share it. Since you can't know whether you need authorization, you can't go and get authorization in advance. And so the only way to be safe is not to share any export-controlled information to begin with. On the other side, if a foreign company is bringing its products in, or a foreign affiliate of yours, a foreign subsidiary of yours, for example, then they need to be aware that temporary imports of foreign goods will require authorization if those foreign goods are described on the United States munitions list. So even though they're not U.S. origin goods, when coming into the United States, they could become subject to the ITAR, and if they are described on the U.S. munitions list, it will be necessary to have temporary import authorization for them. If you're not doing a temporary import, if you're bringing something in from abroad to use at a trade show, but it's going to be a permanent import, then if your item is an ITAR-controlled item, you're going to have to consider whether it's also on the United States munitions imports list, which might require an import permit from BATFE, but that's a less common situation. What about if you have a foreign affiliate or a foreign sub, or you yourselves are bringing in foreign goods that are subject to the export administration regulations? Those aren't going to require import authorization because the EAR doesn't regulate imports in that way. But when you go to send that foreign product back after the trade show, you might need export authorization. Once it comes into the U.S., it's subject to the EAR, and to get it out of the United States again, you have to consider export authorization. There is a section of our favorite friend, the license exception TMP, that deals with exports of items subject to the EAR that were brought in temporarily for trade shows. It's 740.9b2, and that may come in handy in most, and it may cover most circumstances you'll run into. But again, it's very important to review all of the conditions for the use of TMP. And you want to do that before you bring the foreign item into the U.S. for the trade show, because you don't want to get it here and then discover that you can't easily get it back out of the country. So with that said, I'm going to pause again and see if anybody is still awake, and if anybody has any final questions before we sign off.
At this time, I'm showing no questions, but participants on the phone, if you'd like to ask a question, please press star 1 and record your name. I'm showing no questions at this time.
Okay. Well, I'm hoping that's because everything was clearly explained and not because everybody is fast asleep and wishing they hadn't joined the webinar in the first place. If anybody has questions that occur to them afterwards, perhaps on review of the slides, please don't hesitate to contact me at the email address on the first slide of the slide deck. And I wish you all a very good afternoon and an enjoyable close to the webinar series.
Thanks so much, Tahlia. I appreciate your thorough overview of this really important topic. And just as a reminder to folks on the call, we will be sending out the net replay and Tahlia's full presentation as a PDF, so you can go thoroughly through some of her slides. So thank you again. Have a good afternoon.
This concludes today's presentation. Thank you for your participation. You may disconnect at this time. Speakers, please stand by for the post-conference.